Hi, I am attorney Nydia Menendez. As I mentioned in the prior video, a good estate plan includes planning for incapacity. The reason this is so important is because approximately 70% of persons aged 65 or older will face some form of incapacity during their lifetime. When someone is alive but does not have capacity or legal authority, this person is the ward. The person with responsibility and authority over the ward is the guardian. The judicial process of appointment and supervision of the guardian's exercise of the legal rights of the ward is the guardianship process. Guardianship is the administration of the ward's person and or property under the court's supervision. This means that the court, not the ward or the guardian, will be in control. To do this, the court will require periodic accountings, usually on an annual basis, and the court must approve all expenses even when the funds are the property of the ward. A guardian must be represented by an attorney who will serve as the attorney of record. Guardians are required to furnish a bond and or complete a court-approved training program. The clerk of the court reviews all the annual reports of the guardian and presents them to the court for approval. There are several forms of guardianship. Some guardianships are temporary, as would be the case in the guardianship of minors or persons that are temporarily incapacitated. Or, if the court finds the ward partially incapacitated, then the court can appoint a limited guardianship. I will note that in Florida, children cannot own property in excess of $15,000 in value. In such cases, the court will require a guardianship of that child's property. This is one reason why I always recommend establishing a trust for any type of gift or inheritance to minors. Doing so avoids guardianship. Also, in the case of minors, the judicial process of guardianship ends when the child reaches the age of majority, just 18 years old, and at that time, the property that was being supervised with the court will be distributed to the child, the adult, without further supervision, which I'm not sure is such a good thing. In any event, the Florida law requires guardianship to protect people incapable of caring for themselves and managing their financial affairs. This is why it is so important to create an estate plan while competent. Doing so could very well avoid the guardianship process, leaving you in full control to handle your affairs privately. Visit our website to register for a webinar where you can learn more about estate planning. If you like this video, please like and share. If you want to see more videos about estate planning, subscribe and ring the bell to be notified when we release the next video. Thank you for watching and see you soon.